So you want to find these multiple copies of records so you can see if they've been altered, because altered records are nuclear, because that's going to what Joe was talking about. It's not fair, it's not trustworthy. How about more? Organized. How are they organized and filed? It doesn't matter what you ask for, you will get a boilerplate objection saying it's overburdensome. You know? What's your name? Overburdensome. It's happened to me. It's just boilerplate stuff. They just crank it out. So you want to ask them, how are these organized? So what you're doing is you're preempting these objections. If someone told you how to find this, how would you find it? How are they indexed? What would a search be like? Then in this particular case, what was the search? I told someone to do it. Well, what did they do? I don't know. Well, you were supposed to come in and tell us how it was searched for so we know if we have everything. And then someone testifying under oath that this is complete. And it's really funny when someone other than a lawyer who is concerned that there might be a perjury problem is asked, is this complete? Well, that's all I know. That's not the question. Is this 100% of the information? And they get squeamish about that because they don't know, because they didn't look. So this is a really cool tool that you can use to make sure you've got all the records. But what you want to remember is, what's your goal in that depot? This is what, again, what Joe was talking about. Be focused. Know what your goal is. In this particular deposition, what you're trying to find out is, do you have all the records? And I've taken something like 170 of these now, and not even one time did I not find records that were missing. Sometimes by design, sometimes accidentally, but there's always records missing. So you want to identify those. There'll be objections that are supposed to be filed within 30 days. You want to neutralize those objections. Is this going to be overburdensome? Is this really privileged? And that's a longer process, but start thinking outside of the box. Are they really answering truthfully? And then make sure it's complete, because if they're not, you've got a record to go after these to see if you've got a complete response. And this is a big deal, because now you're not going to have many motions if you build a tight enough record. Frankly, the only time I ever have a motion on these things after a document depot is when there's a debate about whether something's privileged or QA or not. And even if you got a record that's not, they're just incapable of accepting that. So it's powerful. And then you talk about what's in the documents in a subsequent deposition, different times. You need time to look at it. So remember, patience is a virtue. It may not be a virtue that most of us have, but it's important. So the sky is pretty much the limit on what you can do for 30B6 depositions. And you can just, all kinds of topics. If you're trying to zero in on electronically stored data, corporate structure, we get that in trucking cases, we get that in nursing home cases, and frankly, we get them in a lot of real estate investment trusts that own shopping malls and stuff. We've done it on medical device protocols. The subrogation we already talked about. Payroll analytics, really a huge area to think about, because those swipe cards, because most corporations do not want to pay employees 1 penny more than necessary. So they swipe in and swipe out, or fingerprint in and fingerprint out. And with that, you will know exactly who is in the building at any given time to identify witnesses. Or if you've got an issue like in a nursing home case where there's a question as to whether or not there are enough people there to do the job, or in a hospital, you can actually find out how many people are in the building at any given moment in time. Now, we just finished a case in Wisconsin earlier this year where we found that, yeah, they had these buildings, but they gave everybody the lunch break at the same time, and so the patients were going bare for half an hour every day, which, you know, I'm not real big on that. If, like, let's say you got kids in a daycare center and say, yeah, well, we're going out for lunch, so we'll just leave the kids alone. Yeah, you can get this from the payroll analytics. We get source codes on programming, product liability testing, bad faith, very rich place to start digging in for looking for documents or looking for positions. But of course, I can hear you saying, yeah, but Mark, I go and I take these depositions and you go, beyond the scope. Who's been there? Yeah, of course you have. You know, anything beyond what's your name is going to be beyond the scope. Well, you know, there's an issue with that. You know, conceptually, I'm trying to put it together. So, you know, you got the lawyer there. You know, the lawyer objects, right? Then the lawyer sustains his own objection. And then the lawyer says, looks like you don't get that information. Because that's what conceptually instructions not to answer for beyond the scope is. And you know, it kind of raises the question of, in any litigation, who's the judge? Yeah, I didn't go to a big-time law school. I grew up on the plains of Iowa. You know, I went to a kind of a middle school in Iowa. I learned some law, got my way through it, learned some things. But you know, there's some like fundamental things that, you know, maybe they do something different in the Ivy League schools. But, you know, when I went to law school, they said lawyers can't rule on their own objections, right? I mean, any schools that you guys go to have a different law than that? Ah, you know what? And here's the crazy thing. There are actually cases on that. It's not the prerogative of counsel, but the court to rule on objections. I mean, the mere fact that that has to be litigated just identifies the lunacy of, you know, the positions they're taking. And, you know, why do they do that? Is because they can. Because most of the time, plaintiffs' lawyers don't want to bring a motion because they're busy. But the problem is, every time they do it, then that authorizes them to do some other ridiculous thing. So let's start thinking about what the law is on this instruction not to answer. Rule 30D1, I suspect Arkansas State has a very similar rule that says you can instruct not to answer for privilege or a court-directed limitation of evidence. And that's it. Well, what about when they're harassing my client? Do you see harassment in the rule? No. If there's harassment, you recess and you go get a protective order. Now, it better be real harassment, because if you're shutting down a deposition and it looks like something that's not harassing, the axe will fall on you. But the rule is pretty big on it. Redwood versus Dobson, 476 F. 3rd 462, 7th Circuit, Chief Justice Easterbrook. Instructions not to respond that neither shielded a privilege nor supplied time to answer violated the federal rules of civil procedure as well as the rules of ethics. And that was a case where the lawyers were just basically dumping on each other. And one lawyer was just goading and harassing a witness, and the defending lawyer was instructing not to answer. They brought cross motions. The trial judge says, you guys are all jerks. I'm not dealing with it. They went up on cross motions for sanctions to the 7th Circuit, and the Chief Justice says, you're going to lose your license if you do this again. It's pretty big, because what the court said is lawyers can't take the rules into their own hands. They have to go to the courts to diffuse these tensions. And you say, well, what does this have to do with 30B6 and going beyond the scope? Well, if you go beyond the scope, that's not one of those two pieces of instruction not to answer. So the sentinel case is King versus Pratt and Whitney. And it says Rule 30b-6 cannot be used to limit what is asked of a designated witness at a deposition. Rather, the rule simply defines a corporation's obligation regarding who they have to produce and what that witness has to be prepared to answer. This is the overwhelming majority rule. There's a case in King that is cited called Paparazzi, or Pappardelle, which says, well, you should restrict yourself to the 30b-6 notice, but if there's a debate that you're going beyond it, the questions will be asked and the court will rule on it. I don't know of any lawyers who I go up against who know this, because they have the thing that they learned in law school. I would argue. I could give a damn what someone would argue. I want to know what the courts say. And the courts say they cannot instruct not to answer beyond the scope. So the issue is, if you go beyond the scope, then that's not going to be binding on the organization. But Rule 26 is still the controlling rule in a deposition, that you can ask any relevant questions or questions proportionately leading to admissible evidence. So it's not a limitation. It defines the minimum amount of information that they have to be prepared to answer. And 26b-1 is what defines the scope. King versus Pratt and Whitney, 161 FRD 475. It is the overwhelming authority on this topic. So fine. So great, Mark. You've got all these great rules, but you know 30b-6 doesn't work, right? Because they're never prepared. They come and go, I know nothing. You guys remember Sergeant Schultz? You know, the Hogan's Heroes? I know nothing. And that's what you get all the time. So say, why waste your time? It's because we go to the courts, and the courts never listen to us. They never grant the motions. Well, the reason they don't grant our motions is because we think our eloquence is going to carry the day, which it won't. We need to do something else. We have to think of a different way to get that peanut out of the tube. We have got to look for another solution. And the solution is one that is actually my theme in all litigation. And that's what I call litigation jujitsu. What you do is your power comes from deflecting the adversary's obstruction on themselves. Because that's what they do. Litigators is that whole new breed of lawyers that has been designed to prevent access to legitimate evidence. And you know what I'm talking about. And sometimes people, you know, who do the same thing. This has got to be about flow of information so we can get to the truth. And how do you flip this on them? How do you cause a situation where the adversary, his own obstruction is going to be dumped on him? And the way you do it is you pull back the curtain. You expose what they are. And the way you expose it is by making a record. So you can bring in deposition transcripts. And when we do the 2-day 30b-6 program, we put up, examples. But you can just start thinking about it. What are the things you're going to do to try to expose all this ridiculous conduct? Because what you have to understand is you got two goals. One is you want to get information. But the other one is you want to show that your adversary is cheating. They're not following the rules. And that's really an important thing that you do by making a record. So how do you do that? Well, we know what we're supposed to do. We're supposed to let them know what we want. You see, now it's all starting to fit together. if we're legitimately telling them what we're looking for, that any legitimate person can look to and say, yeah, of course that's what you're looking for, and they're supposed to respond, now our duty has been fulfilled. We've told them what we want to know, and now they need to tell us. Pretty simple, right? And so how does it work? We tell them what we want to know. They pick the person. And now all of a sudden people go, oh, Mark, I'm not real comfortable with them picking. Because, and start thinking about that. Some of you might have significant others who have suggested that you individually and we as a profession are control freaks. Huh? You've heard it before? No, never. No, I mean, we like to say, I want the design engineer on this floor on this day. And that's a paradigm shift we got to get away from. We got to say, we want to know what the organization knew. And they're going to pick. And what this is you are now shifting the burden to them. So now if the wrong person is there, it's their fault. If we pick the person and that person doesn't know the answers, then they say, well, Mark, if you would have asked for the right person, you would have got the answer. But you had to pick Joe, and Joe doesn't know the answer. Okay, fine. So what you have to do is you got to let it go. Those of you who are sailors, you fight the wind, you tip over. Those of you who are skiers, you can ride the mountain, or if you fight the mountain wins every time. Ride it, give up some power, give up some control, and enjoy the ride. Because once it shifts to them, they will experience what is known, and this is a legal term, the pucker factor. Because now they can't flip it on us. It's their fault if the wrong person is there. But you have to understand the legal framework to make that happen. They've got a number of duties. The first one is the duty to show up. I mean, I bet you there's people in this room that have had the same experience as me who said, I object to this, we're not coming. Anyone ever had that? We're not showing up for the depot? I got news for you. Under any depot, 30B6 or otherwise, lawyers cannot unilaterally cancel a deposition. We try to have a professional, congenial environment where we work together to schedule for the convenience of everyone, but that has limits. We send an email, we want to take a depo, let us know. Send one 3 days later. We want to take the depo, give us some dates. 3 days later, we send another one, give dates. Often we'll call and document it over that 7-day period. You know the drill, they never respond, right? So then you note the deposition, say, since I didn't, and with a cover letter, since I didn't hear from you, I've noted the deposition. If this doesn't work out for you, here are 17 other days within a 40-day window that I have available. But let me know. I'm not available for 120 days. Well, that's not going to work for me. So, well, I'm not showing. Well, bring a motion. Let's talk to the court and say, you accepted a case that you don't have time to work on. Because that's an ethics rule that says you are not allowed to take on a client that you do not have time to represent. So I'm going to work with you, but let's have it within a reasonable amount of time. So, well, let's cancel it and come up with another day. I've been to that movie. As soon as we agree on another date, I'm happy to continue it. But unless we have another date, I'm not going to continue it. Well, you're being a jerk, Mark. No, I'm not. I've given you 17 days. You got more days? Let's find a date to work. Let's work together, but we're not going to play this stall game that it goes on indefinitely, which everybody in this room has experienced. I know you have. All you have to do is note one deposition and you've been there. Now, and there's more to it than that here. In the 30b-6, you even have more power. It's called the Rules of Civil Procedure. 37d1a1 sanctions if a person designated under 30b-6 doesn't show up. The rule, this isn't heavy-duty legal research. This is right in the rule. You don't show up, sanctions. What do they say? Well, we objected. Good for you. Rule 37D says failure described in the rule is not excused just because it's objectionable. You got to bring a motion, and you have to have a pending motion for protective order. Now, here's the part where it gets kind of crazy. So it says, unless you got a motion pending, it's sanctionable not to show up. I thought pending was pretty clear. It's not. In a very significant number of states, Georgia, Arizona, Minnesota, you have to have an order. You have to have an order saying that the deposition is going to not go forward. Some states just say if you filed a motion, then that's enough to stay the depo. But an awful lot of states don't. And I apologize for not having researched Arkansas. You have to have one? Bryce! Let's hear it for Bryce Cook. Yeah. Arkansas has to have, according to the law of Bryce Cook, says that you have to have an order in place, otherwise you have to show up. And that's actually a good rule, because oftentimes what happens is you'll get the motion the night before. And there is another series of cases out there that says if you're in a state that says you have a motion filed, it has to be a timely motion. If someone has known about this deposition for 45 days, they can't wait 43 days to bring that motion. They got to do it, when they get it. Otherwise, it drags on forever. So they got a duty to show up. That's rule number one. Number two, they've got to pick the person. Officer, director, managing agent, or person who consents. A lot of times they put up people who don't even know they're being put up. So if they don't go managing agent or above, you have to ask that witness, do you agree to bind the corporation? I've had things that says, I'm not binding anybody. Like I'm a clerk. And then the defense lawyer will go, well, we designated him. That's not the rule. So they've got to pick someone, okay? And then here's the important thing. This is where the power comes. So I want you to just kind of like take it in. Duty number 3 is they have to designate a person who provides all information known or reasonably available to the corporation. It doesn't say the person with most knowledge. All information known and reasonably available. And they say, well, they come in and say, well, to the best of my knowledge, well, that's not the standard. It's not the standard, it's what their knowledge is. Because this is a deposition not of this individual. This is a deposition of the organization. And they have to provide all information known or reasonably available to that organization. And it's all institutional knowledge. We're back to U.S. v. Taylor, the big dog. The testimony elicited on 30b-6 represents the knowledge of the corporation, not the knowledge of the individual deponents. I mean, are you guys seeing any ambiguity in that? Not the individual, everything that goes to the corporation. And this is universal. It's everywhere. This is what the rule of 30b-6 stands for. This is to get past all that jerking around. They call it banding in the rule, sending you back and forth. We want to know this stuff. Just tell us. It's not a game. Tell us. So they got to provide all information known to the individual or to the organization. So visual support. The organization, not the individual. Are you taking it in? This is where the power comes. This is really important stuff. Not the person with most knowledge, all information known to the organization. You guys think you got it? I'm hoping you will remember this now, because this is where the power comes. And what we do is we ask questions, and at the deposition college, we spend a whole day on this. How do you establish that they have done everything? Who are the people who have information responsible to this or responsive to this question? Did you talk to them? Did anyone talk to them? What are the documents? What is the electronically stored evidence? They never look at it, ever. So what you have to do is you got to build the record for that, okay? So how do you do it? They got to prepare. I like Procast, but every case says this, so it's not a big deal. They have to look, and they got to be completely and fully prepared to address the questions that are going to be asked. Procast Catalina Lining 193 FRD 633. It's got a lot of research that it sends you into. So, the big difference is if you depose them under 30B1 as an individual, they have no duty to prepare. They tell you what they know. If you depose them, the identical person, as a corporate designee, the organization has a responsibility to prepare them. And it's really different because that's where you take care of the getting jerked around part, which happens in virtually every case unless you've pulled down your adversary's pants on a prior case. Then they know. So, and this preparation is more than just, talking to people. If you were asking for positions, remember,